Okay, gentlemen, where are we on this?
Your Honor, this is a case that Your Honor granted a judgment for possession back on October 29, 2021, which was appealed by the defendant to the circuit court. Judge Connors dismissed that appeal and affirmed the judgment. An application for leave to appeal Judge Connors' order was filed with the Michigan Court of Appeals and denied. An application for leave was then filed for the review of the Court of Appeals denial with the Michigan Supreme Court, and it was denied there on October 31 of 2023. The case arises out of a foreclosure of a mortgage on the property that foreclosed on September 12th of 2019. On March 10th of 2020, 2 days before the 6-month statutory redemption period would have run, Mr. Logan, as plaintiff, filed a complaint to quiet title against my client only, challenging the foreclosure process. He got an ex parte order extending the redemption period and ultimately had to amend his complaint because his claims were against the mortgage holder who foreclosed. The Court of Appeals dismissed that appeal and affirmed Judge Archie Brown in the circuit court, dismissing Mr. Logan's complaint to quiet title. In the interim, as the court will recall, this court has entered an escrow order on January 4 of 2002, requiring Mr. Logan to pay rent in the amount of $1,500 per month during the pendency of his appeals, which, according to information I've obtained from the court, he did continue to do from January of 2002 until November of this past year, 2023. He has remained in the premises during December, and according to my client, he did surrender the keys to him this morning at 8:15 a.m. That's where the case takes a shocking turn, Your Honor. My client, once he got the keys, and he's on Zoom, he's at this hearing, he went over to the home and found the home in a terrible mess, and that the entire furnace has been removed from the home, along with light fixtures and everything else. In this weather, Your Honor, my client is going to have to replace the furnace immediately if possible. But the damage to the home is substantial. We got an answer to our motion, which was filed at least 2 weeks ago or more, yesterday by email from the defendant and his attorney. The only defense asserted is that my client supposedly is going to make a profit of $150,000 or more or less on his purchase of the property during the statutory redemption period. Your Honor, he has been denied possession since March 12th of 2020, after the statutory redemption period would have run and after it was extended, and while all these appeals have been taken. We were asking for an order for eviction, but based on the surrender of the keys and the possession of my client, I don't believe an order for eviction is needed. But we do have more compelling reasons. Well, first of all, Your Honor, the amount that my
Bottom
client,
line, counsel, you want how much is in escrow?
$34,500.
You want the 34.5 that's in escrow
as soon as possible, Your Honor. And based on the answer filed by the defendant that the property is supposedly worth $297,000, a rent of $1,500 per month at this point, Your Honor, is obviously a substantial bargain to the defendant who has stayed in there and has paid that amount up through, but not including the December or January.
I get you may have a complaint with that, but now he's gone.
He's now gone. Yeah.
Mr. Fair, what's your position on the 34,500? I think that's all that I've got left here.
Yeah, that's correct, Your Honor.
Your client, you would acknowledge, has surrendered possession of the premises.
Absolutely, Your Honor.
All right. So now what's your client's position on the 34,500?
Well, Judge, I think the plaintiff should be real happy that my client has appealed this issue, because at the time of the sheriff's sale, the value of the property with regards to the sheriff's sale was $145,000. If the plaintiff had taken possession of the property and attempted to sell it, he would have gotten about $145,000. But no, we went through this appellate process, and now the property's worth almost $300,000. I think he should be happy.
There's no furnace, there's no fixtures. I have no idea.
Oh, well, yeah.
But, okay. I'm not here to necessarily make anybody happy. All I need to know, and all I am trying to figure out, is what's your position on the escrow?
Well, I think my client should be returned to escrow, Judge, because escrow is a function of the discretion of the court, number one, and number two, the court should look at the facts and circumstances of the case. Number one, the plaintiff never owned the property. Never. They never. It's not like he had this property, gave it to the defendant, and then the defendant, quote unquote, destroyed it, and we don't even know what the condition of the property is. I mean, I'm hearing this for the first time. But assuming my client, who owned the property, has every right to take whatever he wants from the property, can take
furnace.
So that's why. So
are you really going to argue with me that he has the right to take the furnace?
Well, Your Honor, it's his property until he turns it over to the plaintiff. It's Judge. I would not be arguing this if the plaintiff had owned the property initially, and then
yes, you would.
No, Judge. No, Judge. In all seriousness, absolutely. But up until that point, it is my client's property to do with as they will. I mean, that's a dichotomy. It is totally different circumstances. But having said that, Judge, we don't know what the value of the quote unquote furnace or any other damages that the plaintiff is claiming. I still don't know how he can claim damages if he's never been inside the property until today or yesterday. But having said that, we're still back to the issue of the $33,000 or $34,000 and the appreciation of the property.
I'm not going to deal with the appreciation of the property. Right now, what I'm going to deal with is trying to restore that property to what it should have been.
Okay.
I mean, and that's what I'm going to deal with.
Okay.
So, counsel, how soon will your client be able to prepare a list of damages and get estimates regarding the property?
Your Honor, at this point, I'm not sure that I don't know that information yet, Your Honor. But Your Honor, under the circumstances, the $1,500 was ordered by Your Honor under the court rule, providing that an escrow order shall enter during appeal, and the court ordered the defendant to pay a reasonable rent for the premises from the date the escrow order is entered. The fact that there's damages, Your Honor, is an entirely separate cause of action. The rent that was ordered to be paid, my client has lost the use of the premises. He could have rented it all this time. But
then I get into the argument of who had rightful possession during the course of the appeal, right?
Honor, but see, that argument of Mr. Fair is contradicted by the Court of Appeals. Well, Judge Archie Brown found that the defendant's complaint to quiet title was dismissed. Title has
listen,
title
listen.
judge. The title has been, his client is not the owner. I mean, that argument has been appealed and dismissed, and your judgment has been appealed once and requested to be appealed twice. Everything is res judicata, Your Honor. They can't go back and argue anything. The only question is, what was the purpose of the rent escrow? And it was to pay rent, the fair market rental value. His client isn't the owner and hasn't been the owner of the property since the Court of Appeals dismissed his appeal. But really, since Judge Archie Brown determined that he didn't own the property, which goes back to 2019, Your Honor. So all we're asking for today and all that's before the court is disposition of the funds in escrow. And that's what I think.
I'm absolutely aware what's before me. I'm just trying to figure out why nobody wants to do what I'm asking them to do.
I do, Judge.
Because my problem is this. I certainly could just release it. Yes, it's rent. What would have been the reasonable rent for the period in time? Is it the 1,500 or is it not the 1,500?
Your Honor, just based on the evidence that the defendant has supplied, 1,500 for a house that's worth supposedly 300,000, ignoring the condition and the lack of a furnace.
I can't ignore it, counsel. I can't ignore that. You're saying he took the furnace out. I don't know if somebody's going to claim that the furnace was there. I have to make an assessment as to how to distribute this escrow. I realize you guys, one wants me to say, well, just give it back to him because the property's increased. The other wants to just say, well, it's rent and do that. We're going to do it my way. How soon can your client get estimates and make a statement to the court as to what they believe the condition of the property was at the time that I ordered escrow?
Dwayne, are you on? Mr.
Yes,
Grant?
I am. Can you hear me?
Yeah, I can hear you.
Well, and also I paid $40,000. I paid $39,000 in taxes over the last 4 years.
You know what?
That was paid by me.
You know what? I don't think I asked to hear from you. I just wanted.
Okay, well, you're all right.
Here's what I'm going to do.
Right.
No, forget it. Forget it. I've asked twice. So we're going to just do it my way.
Give
me a date 45 days out.
March 5th at 9 a.m.
Matter will be adjourned to March 5th, 2024, 9 a.m. Maybe you guys can figure out what you want to do on this. In the interim, I want an estimate of the damages and a statement regarding the condition of the property. Thank you.